I have three brief readings for you this morning. The first is from Magna Carta itself, June 15, 1215. Listen to the gender-specific language of this, because that will become relevant in the reflection that I will be giving shortly. No freeman, free man, shall be taken, imprisoned, deprived of possessions, outlawed or banished, or in any way destroyed, nor will we proceed against or prosecute him, except by the lawful judgment of his peers, or by the law of the land. The second is from 1866. Congressman John Bingham of Ohio, in those days there were radical Republicans. He was a radical Republican leader during the Civil War, and he proposed the Equal Protection Clause of the 14th Amendment. And he said, "Is it not essential to the unity of government and the unity of the people that all persons, whether citizens or strangers within this land, shall have the equal protection in every state of the Union and the right to life, liberty, and property?" And in 1982, Justice William Brennan, writing about a case from Texas involving the right to education of the children of undocumented families, said, "The protection of the 14th Amendment extends to anyone, citizen or stranger, who is subject to the laws of the state, and reaches into every corner of a state's territory." This reflection will be about inclusiveness. The idea that everyone is entitled to due process of law, that everyone is entitled to the equal protection of the law. The idea for using the occasion, almost the 800th anniversary of Magna Carta, is not my idea, it's Gene Walker's idea, one of our most reflective and thoughtful members, who suggested that we should use the occasion of June the 15th, apart from Father's Day, to recall the Great Charter. The Great Charter was signed and sealed by King John I of England. He was the younger brother of Richard I of England. You may remember from elementary school, he was Richard the Lion-Hearted, remember that? In troubled times, Richard had left to embark on the Third Crusade. It was the Third Crusade because a leader known as Saladin the Great reconquered the land of Palestine, including Jerusalem, in the year 1187. So the Crusaders set out to make things right, to reconquer the Holy Land and to set things in order. But that, of course, is another story. The Magna Carta actually has nothing otherwise to do with the Crusades. King John ruled in the place of Richard, and he ruled through, here's a wonderful phrase, royal prerogative. You may have heard the President of the United States, both Democrats and Republicans, claim presidential prerogative. Did you know that? Anyway, royal prerogative, and King John ruled through his minions. Minions? I love that word, minion. One of the first times I ever heard the word minion, one of my students was having her child baptized in a Catholic church. It was the first and so far only Catholic baptism I had ever attended. And we were asked during the service to rise and raise our hands and swear that we would no longer support Satan or his minions. And I did what I was asked to do, but I thought, I'd like to think that over for a while. I've never been asked to forswear Satan and his minions, and I probably never will again. Minion is a wonderful word. It has to do with what is called servile subordinate. A minion is a servile subordinate of someone in higher authority. You may have heard of John Yo. You ever heard of him? Y-O-O? He's a law professor and a member of the law faculty at the University of California at Berkeley, who was in the Office of Legal Counsel in the Department of Justice during the administration of George W. Bush, and he thought that President Bush had prerogatives, and that the President of the United States had inherited his prerogatives directly from, are you ready for this? King George III of England. So that's good. Transcendence. It passed down from George III to the President of the United States, and therefore, according to John Yoo, the President of the United States had royal prerogative. Okay. In King John's day, his minions were not sufficiently servile. They were, it was a feudal system, they were the lords of their own manners. Okay? They ruled portions of England, and they did not like the idea of being entirely subservient to the king. So they forced King John I to sign the royal charter. The barons, the lords of their own manors, got their rights protected by due process of law, by the law of the land, in the year 1215. That is the origin of the idea, I think, which we should cherish for our inheritance from England, one of the things we should cherish, that no person, even the king or queen of England, should be above or beyond the reach of law. Everyone in our society is subject to the fundamental principles of the rule of law. We should note, however, that when they drafted the charter, they did not just claim the protection of law for barons. They granted the protection of law to all free men, not to slaves. You may notice, not to women. It was only free men. That idea of the people being subject to the law was also one of the factors in our own revolution with the principle, you remember this from elementary school, no taxation without representation, okay? And in our own time, the Tea Party has picked that up, but that also is another story. Our United States did not really claim equal protection of the law for every person, even though John Bingham, who wrote the clause, thought every person should have that protection, because we had slaves. It took the Civil War to free the slaves, and we had, therefore, after the Civil War, we have freed men, not free men, but freed men. But we no longer, or not yet at least, had free women. Okay? So, it took another 100 years to claim the rights for free women. The precise date is 1971. All the women present may not know or recall that date, but in 1971, that's when it was determined by the Supreme Court of the United States that women were entitled to equal protection of the law. I'm going to tell you 3 stories about how inclusiveness has come to be. And I think they are vivid, and it's a way to bring the abstractions of law down home to us where we live and to understand it in an immediate and practical way. So my first story is the story of Shuffling Sam Thompson. Ever heard of Sam Thompson? Shuffling Sam is his name? I don't shuffle very much. Okay. Shuffling Sam Thompson was from Louisville, Kentucky, and his case before the Supreme Court of the United States was decided in 1960. On a Saturday night in Louisville, Kentucky, at the Liberty Inn Cafe, there were two policemen who came into the cafe, and they saw Shuffling Sam out on the dance floor of the cafe dancing by himself. He was shuffling. Okay? The officer said, "What are you doing here?" And Sam said, "I'm waiting for a bus." It was true, but the bus was not due for another hour or so. In the meantime, he was shuffling. They arrested Shuffling Sam for loitering and for, get this, disorderly conduct. It might be disorderly if I was shuffling, but I don't think it was for him. He had been arrested 54 previous times for vagrancy. He was prosecuted, found guilty, and fined $10. Now, the law of Kentucky provided in 1960 that if you were prosecuted of a petty crime like this, and if you got a fine that was less than $20, there was no appeal. He was done. It was all over. Guess what? You got a lawyer, a volunteer lawyer, and you appealed. And where do you think his case went? From Louisville, Kentucky, to the Supreme Court of the United States. A direct appeal from the Municipal Court of Louisville, Kentucky, to the Supreme Court in Washington. And Justice Hugo Black of Alabama wrote to the Supreme Court that we find no evidence whatsoever in the record to support his conviction. Guess what? Due process of law means that you can't be convicted of a crime for which there is no evidence. The fundamental requisites of due process of law is that you're entitled to notice of what you have done under a specific law. You're entitled to a hearing. The burden of proof is on the government to prove your guilt. You have an opportunity to respond, but Shuffling Sam was accorded none of that. So the Supreme Court of the United States said he was not given due process of law in 1960. Now, the next person you may have heard of, his name was Clarence Earl Gideon. Ever heard of Clarence Gideon? There was a book by Anthony Lewis called Gideon's Trumpet, and in fact, there was a movie made of it with Henry Fonda many years ago now. Clarence Earl Gideon rifled a vending machine in a bar, and he was convicted. He was tried without a lawyer of any sort, no legal assistance of any sort. He was convicted, and he was sent to the state penitentiary for rifling a vending machine. And he got a piece of lined paper in prison. He wrote in longhand a petition to the Supreme Court of the United States. And they granted his writ. They granted his piece of paper. And they said, we will give you a hearing. And they appointed Abe Fortas, who was later a justice of the Supreme Court and was the attorney, actually, of Lyndon Johnson. He was a member of a major Washington law firm who represented Clarence Earl Gideon. And in 1963, in the case of Gideon versus Wainwright, the Supreme Court said, before they can put you in prison, you're entitled to a lawyer. If you can't afford yourself, one will be appointed to represent you. It is the law of our land now that before they can put you in prison in any municipality, county, state, or federal prison, you're entitled to the appointment of an attorney. Okay, that helps a little bit with the men, but let's talk about women. Let me tell you the story of Sally Reed. Okay? Sally was married to Cecil Reed, and they lived in Boise, Idaho. Their son was deceased and left no will. So if you don't leave a will telling who you would like to be the executor of your estate, the state appoints one for you. The law of the state of Idaho said, if you die and leave heirs, and there's more than one heir, any male heir must be presumed competent over any female heir. You like that? So that would, if you had a son and daughter, your son was a dropout and living in the wilderness of Idaho, like Ted Kaczynski, if you knew Ted Kaczynski, living in the outback, doing nothing, and your daughter had a MBA from Harvard Law School, under the laws of the state of Idaho, your son would be the administrator of your estate, not your daughter. And the Supreme Court of the United States, in Reed versus Reed, in 1971 said, if you're having that kind of presumption, it was called an irrebuttable presumption. In other words, you can't contradict it. If you have that kind of irrebuttable presumption, that denies women the equal protection of the law. Sally Reed was represented by Ruth Bader Ginsburg. Heard of her? She became a member of the Supreme Court in 1980, and she was for a long time the head of the Women's Project of the American Civil Liberties Union. So it took, from the time the 14th Amendment was ratified until 1971, it took 103 years for women to be recognized as having constitutional protection under the Equal Protection Law. 103 years. Okay. Now you may relish that, but let me go back to 1873 and tell you quickly the story of Myra Bradwell. Ever heard of her? Myra Bradwell was a woman. She was working in her husband's law office. She studied law. She took the Illinois bar exam and she passed. But Illinois would not admit her in 1873 because she was a woman. And they said women have no right under Illinois law to practice law, and we will not use the Equal Protection Clause to overturn that in 1873. Now, you may think that's bad enough, but it gets worse. Let me read you quickly what Justice Joseph Bradley wrote in 1873 about Myra Bradwell. I can't do this with a straight face. It's hard. You can laugh if you want to. I quote, "The natural and proper timidity and delicacy which belongs to the female sex." So all of you there, you're delicate and timid, right? The natural and proper timidity and delicacy which belongs to the female sex evidently unfits it for many of the occupations of civil life, he wrote. It's worse. The paramount destiny and mission of women are So in 1873, not only did women not have the Constitution on their side, the Constitution was trumped by the Creator. Okay? Fortunately, in our time, we don't usually refer to the Creator as trumping the Constitution. We can do better than that, I think. Let me give you one more. I'm watching the time. I'm just about there. Okay. In 1982, a case from what is called the Mississippi University for Women. You ever heard of that? Mississippi University for Women had a nursing program. Just as the university was open only to women, the nursing program was open only to women. And so when a male applied for admission to the nursing program, the Supreme Court wrote in 1982 that the idea that only women could be nurses was, I love this phrase, it's one you can use, an archaic and stereotypical generalization. You got that? Put it in quotes. If you're a woman, anytime anybody gives you any crap, you say, wow, that is just an archaic and stereotypical generalization, Johnny. Okay. Now, we are in the process of extending the Equal Protection Clause right now to include sexual orientation as a category that will be fully protected by both the Due Process Clause and the Equal Protection Clause of the 14th Amendment. You can take some pride in the fact that Fort Worth, years ago, adopted a municipal ordinance that protects against employment discrimination and housing discrimination within the corporate limits of the city of Fort Worth based upon sexual orientation. We were one of two cities to do that. It was Austin and Fort Worth. We did that quite a while ago. I actually spoke before the city council when that was being adopted. Chuck Silcox, if you have been in Fort Worth a long time and remember him, was a conservative member of the council, but he spoke up and was a real stalwart on applying sexual orientation as a protected category under the 14th Amendment. So the point I'm making, and there's still hope for us, even with the conservative Supreme Court, most of the law that is changing in an inclusive direction. Now, so far, we have never gone back the other way. We have never taken a category of people that are protected and say, oh, no, we no longer are protecting them. It's always been from exclusion toward exclusion. And just as Dr. Martin Luther King talked about the curve of history is long but always upward, I think we can take some pride in the fact that our evolution has been toward greater inclusiveness. And if you've been in Texas as long as I've been, that gives us many things to hope for. So we're getting there. The good thing is most college students these days don't really, I'll put it bluntly, give a damn about this stuff anymore. They accept inclusion. The idea of exclusion is an alien notion to them. So we can do better, we will do better, and there is hope for the future. If you remember, this is something I do frequently with my students. This is how to keep your head on reality. Most college freshmen that I will teach in September do not remember that Bill Bill Clinton was President of the United States. Have you thought about that? That's the way time passes. Just do the math, it works out. You can pick any generation. When I was a kid, I was probably as close to the American Civil War in time as we are now to World War II and the rise of Hitler's Germany. So there is hope if we keep our heads to it and are attentive to the purposes. The original constitutional design, the original Great Charter said no one should be above or beyond the protection of the law, and we can take pride in that. And let me say, so may it be. As we rise in body or spirit,